So since we have only an hour allocated for this program, we're going to get started right away. I'm Mary Ann Glendon, and I'm a member of the Vaughan Lecture Committee, so it is my pleasure and my privilege to introduce the program, which exists thanks to the generosity of Mr. Herbert Vaughan, who endowed these programs and lectures, I'm quoting, to promote understanding of the founding principles and core doctrines of American constitutionalism. And it's also my privilege and pleasure to introduce our very distinguished panel today, our principal speaker and two panelists who will comment on his remarks. And I could, if time permitted, say a great deal about each one of them, but what I will say in a brief introduction will suffice to let you know how very lucky we are to have three formidable public intellectuals with us. Professor Robert George is the McCormick Professor of Jurisprudence at Princeton, and he is the chair of the United States Commission on International Religious Freedom. Professor James Stoner comes to us from the Political Science Department at Louisiana State University, where he heads the Voegelin Institute, and he writes marvelous books on American constitutionalism. And Yuval Levin, our principal speaker, is the founding editor of National Affairs. He's a fellow at the Ethics and Public Policy Center in Washington, D.C., where he is a veritable fountainhead of books and articles on a wide range of political subjects, including my own personal favorite, the great debate between Edmund Burke and Thomas Paine. Welcome, Yuval, and please join me in welcoming this wonderful panel.
Mary Ann. All right, well, thank you very much, Mary Ann, and thank you to all of you for being here. I'm enormously grateful for the invitation, very humbled by it, and especially by the company I get to keep here. I'll speak briefly so that we can have a conversation, but we'll introduce the large question of religious liberty by opening with a kind of confession I should make at Harvard Law School, which is that I'm not a lawyer. I'm a student of political philosophy in the American political tradition. I've been in some respects a practitioner a little bit in the world of public policy. And in a sense, it's as a non-lawyer that I want to speak to lawyers and prospective lawyers who are concerned about the question of religious liberty, because the point I want to convey is about the limits of legalism in our defense of religious liberty, and about what a proper understanding of the role of the law in that defense, and therefore really of the role of religious liberty in the life of our country, might look like. The need for an aggressive defense of religious liberty is in many respects more obvious now in American life than it's been in an awfully long time. We are living in a time when a lot of religious Americans and religious communities in America are finding themselves pressed in and really, in some respects, oppressed, or at least forced to confront the tensions between their lives as American citizens and their commitments and obligations to their religious convictions. And again, we have fallen back on the defense of religious liberty as the way to live in this difficult moment when both the government and, in many ways, the larger culture are forcing religious Americans to make difficult choices between playing key roles in the life of the country and abiding by their convictions. It is right that we should fall back on religious liberty in that situation. It's, in a sense, obvious that we should. That's what it's for. It's there exactly to protect us in circumstances like this. And yet there are also enormous risks in doing that. And they are risks that, in this particular moment, should force us to understand some of the limits of our tradition of religious liberty, of our practice of religious liberty, and should also help us see some of the special strengths of that tradition and that practice that we're not used to calling on, and that maybe this particular moment requires us to call on in some unusual ways. So I want to raise, in a sense, two related arguments, one about the law and one about community life in America as they relate to religious liberty, and start a conversation from there about this unique moment, this particular moment for religious communities in our country. The legal arena is where the case for religious liberty is in a lot of ways most straightforward, and we often think of the question of religious liberty as a legal question, especially, of course, because of the First Amendment. And the two kinds of protections afforded by those brief 16 words in the First Amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, provide us with a kind of shape to the arguments about religious liberty in our country. But our first instinct in the legal battles that have been spawned by some of the controversies around religious liberty in the past few years has been to fall back on the free exercise clause. That is to say that what's happening is a violation of people's right to exercise their religion. It's easy to see why that should be. Free exercise jurisprudence involves, as it's taken shape, the creation of various kinds of accommodations for people who find themselves facing impossible choices. And in a sense, that's what it's for. It's to make sure that people are not required to make impossible choices between their roles as citizens, on the one hand, and their religious convictions and commitments on the other hand. But I think it's important for us to see the limits of the free exercise clause and the way in which those limits come from the tradition that gave rise to the free exercise clause. The logic of free exercise is a highly individualistic logic. While right now, the problems that a lot of religious Americans and cultural traditionalists in our country confront are very often communal or, in the deepest sense, corporate problems. The free exercise clause offers a defense of religious freedom that is rooted in a defense of individual conscience, and in turn in a broader liberal logic of individual rights. And those roots run very deep in a way that should be instructive for us now. The English tradition of religious toleration, which is the source of our legal ideal of the free exercise of religion, arose in the wake of long and bloody religious wars to allow for some peace among conflicting sects by keeping individual belief out of the state's reach. It's important to see that this was done in a society with a very strong established church, so that the freedom that was enabled by religious toleration originally, at its origins, was a freedom of private worship and belief for dissenters, but not quite a freedom of common action in the public square. Religious freedom in this sense was a very liberal liberty. It was a freedom afforded to individuals, essentially to keep them out of one another's hair and to keep the commons peaceful and orderly. And the circumstances of early Enlightenment Britain meant that this form of toleration itself was selective. It was intended to protect Protestant dissenters and Jews later, but to offer less protection to Catholics, quite intentionally. And that aim meant that toleration in Britain took a form that is problematic for us now, trying to defend religious liberty in the circumstances that we find ourselves in. We can see that throughout the early writings of the English toleration tradition. I suggest, for example, looking at John Milton's Areopagitica, which is worth doing anyway, and makes a very bold call for freedom of conscience, including for religious toleration, and then turns right around and says, of course, I don't mean popery. It simply excludes, with a wave of the hand, Catholics from the group of protected religious minorities. Even the greatest statement of that early Enlightenment toleration tradition, which is much more sophisticated about this, John Locke's Letter Concerning Toleration from 1689, shows us something of the same troubling form. Locke argues that there is no reason to ban the belief or the profession of any article of faith, since belief can't do any harm. He says, I'll just quote a sentence. He says, if a Roman Catholic believes that to be really the body of Christ, which another man calls bread, he does no injury thereby to his neighbor. If a Jew does not believe the New Testament to be the Word of God, he does not alter anything in anyone's civil rights. Individuals can believe whatever they like. But institutions formed around such beliefs were not similarly tolerated if their purpose was to exist for a purpose beyond the expression of faith. And this was, of course, especially a problem for Catholicism, which is a uniquely institutional religion, and it was intended to be such a problem. Locke specifically says that the institutional existence of the church, the hierarchy that answers to the Pope, who he calls a foreign prince, presents a special problem. And the Act of Toleration, enacted by Parliament in the same year, in 1689, enacted this distinction. There are echoes of this in unexpected places in our own time. In 2012, when the Obama administration first proposed the so-called HHS mandate that requires employers to provide insurance coverage that includes free access to contraceptive and abortive drugs, the rule included an extraordinarily narrow religious exemption that defined a religious institution, a religious organization that was exempt, using three distinctions it has to meet. The inculcation of religious values is the purpose of the organization, and it primarily employs persons who share its religious tenets, and it serves primarily people who share the religious tenets of the organization. This is an extremely narrow definition. It basically includes houses of worship, or institutions that otherwise directly express the teachings of articles of faith. No religious charities qualify, no hospitals, no schools, no adoption agencies, let alone private institutions that are run by religious people. And there is in this an echo of that earliest form of the narrow form of religious toleration from which our tradition began. It doesn't come from nowhere. Now, the case law that arises, that's arisen out of the Free Exercise Clause, of course, has involved a broadening of that kind of definition and the creation of various kinds of accommodation for religious people who want to function in the public square. But accommodations for religious institutions, nonetheless, have been rare in that tradition. Accommodations for private businesses owned by religious people, all the more rare, not non-existent, but rare. In this tradition, in this strand of our tradition, religion has rarely been treated as one of the things that people do together. But there is another strand of our tradition that can help us think about this problem, and at the same time can help us see the limits of purely legal approaches and purely rights-based approaches to religious freedom, and still the breadth of the meaning of religious freedom as part of our political tradition. James Madison actually was important among the original architects of these kinds of arguments. In his 1785 essay, A Memorial and Remonstrance Against Religious Assessments, which was written to oppose a law that would have used public funds to support Anglicanism in Virginia, Madison laid out his basic case this way. I'll quote to you one short paragraph. He says, "It is the duty of every man to render to the Creator such homage and such only as he believes to be acceptable to him. This duty is precedent both in order of time and in degree of obligation to the claims of civil society." So in other words, religious liberty in this view is not exactly or not exclusively a liberal liberty, at least as we are used to thinking about our rights. It's not a freedom to do what you want, it's a freedom to do what you must. It describes a duty of society to retreat and give its members space to act on what they deem essential. It's an acknowledgement not exactly or not simply of a human liberty, but of a human liberty that's tied to a human obligation that precedes the social obligation and shapes it. And Madison also recognized that at the core of that kind of freedom is the freedom not to be coerced into doing what your religion prohibits you from doing. He proposed that the liberal society should make room for a moral code that comes with constraints. In fact, he suggested a society that refuses to allow its citizens to be constrained by their religious convictions is an unacceptably coercive society. Its very liberalism becomes oppressive. But note that Madison makes this case not in the service of a protection of the free exercise of religion, but rather in opposition to the establishment of religion. His point was that no one ought to be compelled to affirm as true a religious tenet that he took to be false, and that no one should be compelled to participate in a religious rite that violates his own understanding of his religious obligations. He was making what we would now recognize as a non-establishment argument that was not exactly or not simply an extension of the Anglo-American case for toleration. But it's also at the same time the essence of the kind of argument that, for example, a wedding vendor who wants to remain free to refrain from participating in a same-sex wedding would advance now. The question of the definition of marriage, for many people, is of course a fundamentally religious question, but it's also at the same time a civil question in our country. And some religiously orthodox wedding vendors are finding themselves effectively compelled by the civil authorities to affirm an answer to that question that violates their religious convictions on that subject. And some religious institutions, from universities to social service agencies to private companies owned by religious believers, are finding themselves forced to take part in the enactment and enforcement of a moral code that they are obliged to reject. They want to be relieved of that compulsion, and they're being told they can't be because the larger society's understanding of the moral life should overrule theirs. In one sense, their experience is more like that of a religious minority in a society with an established church than it is like that of a religious minority simply being denied the right to exercise its religion. Now, that's not to say that liberalism or progressivism or whatever we want to call it is literally becoming a religion. That's certainly not my point. But it is approaching the question of society's moral order from the point of view of a dominant established power that expects to command assent to its views in the public square. People are allowed to believe whatever they want, but when they act together in public, they have to abide by the beliefs of the established order. That liberalism is not an actual religion means that the Establishment Clause is not going to serve us as a legal tool, even in this situation. Arguments in court have to continue to be made through the Free Exercise Clause, which offers some vital protections. But the fact that Madison's argument against religious establishment still speaks so powerfully to the situation of a lot of religious believers today can help those believers understand their situation better. And I think above all, I'll close with this, it brings into sharper relief the distinction between individual and communal religious liberty. In calling for keeping our national life free of the overbearing power of one church, Madison was not suggesting that instead we should have zero, but that we should have many. And by withholding public sanction from any one set of religious institutions, his approach makes it possible for many religious institutions, not just many religious individuals, to populate our public life. But of course, Madison's assumption, and the assumption really of the entire tradition of religious toleration until the last few decades, was that religious diversity and conflict would involve competing sects that differ on some significant questions of doctrine and practice, but still share in common some basic Judeo-Christian orientation that at the same time is, in very broad terms, our society's implicit civil religion. The erosion of that common soil, of that common culture, whether you think it is a good thing or a bad thing, is the essence of our modern condition when it comes to thinking about this question. And that erosion means that, in a sense, protecting religious liberty now means not only allowing individuals to hold somewhat different views or to practice somewhat different tenets, it means building space for entire cultures that differ on some fundamental questions. It means building room for communities to live out different views of what religious freedom means and of what the free society means. That is, without question, a much taller order than what Madison imagined his approach to religious liberty would be required to support. But his approach, nonetheless, gives us a lot of tools, both ways of thinking and ways of acting in the public square and in the courts, that can help us understand the importance of thinking communally about religious liberty. And for religious people in particular, it's extremely important to think communally about religious liberty, because what that means is that we don't simply approach our society defensively, that we don't simply approach our society asking to be protected, asking to keep what we have, because what we have is a vision of the good that we think would be good for everyone, and not just for ourselves, so that we in fact do ourselves a very great disservice when we approach the rest of our society purely defensively. Instead, we have to think about approaching our society with a sense of what we have to offer. And in our circumstances now, the only way to really offer that sense is to build thriving communities that offer an alternative, a living alternative to what we think and what many others who aren't religious might think is wrong in modern life. The only way to really do that is in the course of community life, is by building cultures that look different. And in thinking about the purpose of religious liberty, the place of religious liberty, we have to think about how it can serve that crucial end. That means thinking a little differently about the law, but it also means thinking about more than the law. And that may be a dangerous thing to say at Harvard Law School, but it means being less legalistic. And in some senses, more practical, more communal, more inward focused, more focused on building what it is we have to offer than on defending the space for it. Religious liberty allows us to defend that space, and it's then up to us to fill that space with something that is meaningful to us and attractive to others. That's the great challenge today. Religious liberty has a great role to play in it, but it's not the only role. I'll close there.
Thank you, Yuval. We have two lawyers here who
More than that, I guess.
Ready to comment. Two who are going to begin the comments. Start with you, Professor George.
I think we may have slandered Professor Stoner by accusing him of being a lawyer. You'll forgive us?
Oh, no. My apologies.
Well, thank you, Professor Glendon. That was a wonderful presentation by Dr. Levin. The thing that jumped out at me at the center of it was his recalling for us that James Madison's conception of religious liberty was as a liberty not to do whatever you want, but rather to do what you must. That's a powerful and important and much overlooked distinction. But it's not one that's new or new to controversy. It's precisely the one that, 100 years after Madison wrote, John Henry Newman in Britain, in one of the great debates over religion and religious liberty in his time, Newman, of course, by then a convert Catholic who would be a cardinal, the conception that he identified, the distinction that he identified, when he contrasted his view of religious liberty, what he believed the right view of religious liberty was, that is, religious liberty as protecting conscience as a stern monitor, with what he called the counterfeit of conscience, that is, the idea of self-will. In other words, the idea of the right to do what you want. And I think that's a real question for all of us when we think about religious liberty and we think about conscience. What is it? Is conscience the right to do what you want? A lot of people would say it is, and would build an idea of religious liberty around that and import that idea into our legal and especially our constitutional life and practice. Or is religious liberty the right to do what you must, or what you judge you must do? Was Madison right? Was Newman right? I would submit to you that, by and large, at least if my experience of 31 years of teaching at Princeton is indicative, by and large, people have adopted what Newman called the counterfeit idea of conscience and of religious liberty. It's the right to do what you want, subject, of course, to the requirements of the public order. And in the contemporary debates, those requirements very often are viewed as overriding without particularly strong reasons for overriding them, the kinds of reasons that you might consider insufficient or inadequate if you held the contrary view, that conscience is indeed the right to do what you must, or the right to do what you judge as a matter of faith and reason you are required to do. My own particular field is the philosophy of law, so I've been laboring in that vineyard for these 31 years. And I think that the contribution that people in my field can make is thinking about the moral foundations, if there be such, of the right to religious freedom. Once again, if I ask a typical group of students, I won't ask you to raise your hands, not one of the professors who does that to his students, but if I did and I asked you, well, what's the moral foundation? What's the basis of the right to religious liberty, or for that matter, other civil liberties? I suspect that the majority of hands would go up for the proposition that it's the fruit of a social contract, it's the fruit of a deal, it's the fruit of a modus vivendi. Why should we respect religious liberty? Well, I should respect your right to religious liberty so that you will respect my right to religious liberty. We make a deal. Now, I would argue that if that's what it is, then whatever the right to religious liberty is, it's not a moral right. It's not a fundamental human right. We will have identified no ground, no moral basis for my respecting your religious freedom if I can get away with not respecting your religious freedom. So I've been on a search for an alternative to the modus vivendi, to the social contract understanding of the right to religious freedom and other basic civil liberties. And here there are two big contenders. The one is the idea that religious liberty is what John Stuart Mill called, while rejecting this conception, religious liberty, or liberty generally, as an abstract right. A right that we can identify and are morally bound to respect, quite independently of any consideration of the value of doing so. This basic approach was captured in a commitment of the great, late, alas, Harvard political philosopher John Rawls, who famously said that the right is prior to the good. At least in political philosophy, the right is prior to the good. Mill rejected that. He rejected it in favor of a view that said liberty must be defended not by abstract right, but by appeal to its value. That's the burden that he sets for himself, establishing that value in the first chapter of his great work on liberty. I think he was right to do that, although I think he was wrong to adopt a utilitarian approach, as he did following his great teacher, Jeremy Bentham, a utilitarian approach to the identification of value. I think the best alternative is a non-utilitarian alternative, but one, nevertheless, that seeks to ground the right to religious liberty in the good that it serves. And what is that good, then? The burden is then on me to say what the good is. Here's what I think it is, and then I'll just conclude my little portion. I think it's the good for each of us, every single one of us. It's the good of raising the great existential questions of human existence, the questions of meaning and value. Where do we come from? Where are we going? What's our nature? What's our dignity? What's our destiny? Is there a more than merely human, a transcendent source of meaning and value, or not? Is there a law above the merely human law, sometimes called the moral law, or Dr. King called the natural law? Dr. King and others, he being the most recent exemplar of this tradition. Is there a law higher than the human law under which the human law stands in judgment? A law that we can appeal to claim that the law is unjust and therefore to stand against it and seek to change it or even conscientiously disobey it. So that's the first part of the good that I think we're trying to protect with religious liberty. And second, the honest effort to identify the answers to those questions. That's what we want for ourselves. That's what we want for our children. We care where they come out. We want them to get the right answers. And since we, by definition, think the answers we've achieved, even if provisionally, are the right answers, we hope our children will reach those answers. But more fundamentally, we want our children to think about those questions and make a good faith, honest effort to answer them. And then the third part, to live with authenticity and integrity in view of one's best judgment about those questions, in view of one's answers. Whether one's answers are, in the end, theistic, atheistic, pantheistic, whether they are Christian or Jewish or Buddhist or Hindu or secularist, to live with authenticity and integrity. It's that tripartite good that it seems to me the right to religious liberty respects. We have the right because there is this very worthwhile thing, worthwhile for all of us and worthwhile for our community, and very much worthwhile for our community to respect in all of us.
Thank you, Professor George. Professor Stoner.
Yes, well, I'm not only, from a point of view of negative liberty, not a lawyer, but from the other point of view, am a political scientist and trained actually at this university in the Faculty of Arts and Sciences, for better or worse. I want to applaud Dr. Levin for his concern for religious liberty lived in communities. And in my short time, I want to raise the question and put to you and to the Assembly about possible legislative action that can if not solve, at least diffuse some of the controversies that now exist concerning religious liberty. The legislative power in a democracy, of course, mediates between society and the law. It probably succeeds when there is a coalition of communities that works together, makes a deal, and a deal that people can live with, even when, or precisely when, their principles are at odds. I have 3 examples in mind. The first is a piece of actual legislation proposed, and then 2 others are some thoughts I've had about possible legislation in the states. So the first one, proposed on June 17th, 2015, was something called the First Amendment Defense Act. It was introduced in anticipation of the court's decision in Obergefell a week later, and was probably introduced in response to a question, or the response to a question, in oral argument of the case, where concern was raised whether, after the court made a decision upholding same-sex marriage as a constitutional right, that whether institutions that advocated the contrary would now lose their tax exemption. And the answer came back, well, that would be an interesting question that would have to be raised at the time. And the reason anyone would have asked that question was because in the Bob Jones case, some years before, the court upheld the denial of a tax exemption to a university that forbade interracial dating, if I remember correctly, and it was held that civil rights legislation overrode a religious liberty claim in that case. The act would make it would forbid the federal government from denying a tax exemption or other federal grants to people who, and in the terms of the act, are otherwise eligible, but they can't be discriminated against on account of their opinion that marriage ought to be between a man and a woman, and that sex should be confined to marriage. Perhaps the point of introducing this was just to fire a shot across the bow, because there haven't even been hearings on the act in almost a year since. But it is an unusual act of legislation, and they didn't simply enact the tax exemption or reenact the tax exemption in words, but presented it as a discrimination question. And it's a rather narrow point of belief that's at issue here. So I'm wondering, what do you think of that? Is that a plausible strategy, or is that misconceived? Secondly, though, I want to turn to something that occurs to me would be a way out of the baker's dilemma now concerning same-sex weddings that you've probably heard about. It seems to me that there's a distinction already in the law that could be made clearer by legislation between businesses that are open to all comers and the rights of business professionals to offer their services by contract. And here the idea would be that for those businesses open to all comers, one would keep with the general duties of the common law to serve anyone who, and the principles of the Civil Rights Act, to serve anyone who comports himself decently in the establishment, and the business owner would actually not have an ability, on the basis of his own belief, to refuse to serve, say, a woman in hijab or a couple that the business owner thinks is gay or whatever. But on the other hand, with respect to contract services, the refusal to make a contract would be presumed legitimate, even if there's some suspicion that the reason for the refusal was disapproval based on a religious opinion of the way of something about the person who doesn't, with whom the decision is made not to contract. It seems to me that this distinction between serving all comers and providing a service for contract runs through most of the activities of civil society. So, for example, we can distinguish between a restaurant and a caterer, right? So that the restaurant is open to business and serves anyone who comports himself in the restaurant. On the other hand, a caterer, if you go into a kitchen, it might be that you don't want to take the job because the kitchen is dirty, and it might be you don't want to take the job because you don't like the ambience of the house or something or other about the people who are considering inviting you. But you don't have to give a reason for that. It's simply presumed that you can take the job or not take the job. I think you can make a similar distinction between a notary who sets up and provides legal affirmation for certain documents, and a lawyer who makes a choice of which client to take. And I don't think, although maybe legal services is different, you can tell me, but on the whole, don't simply take every client. A lawyer isn't obliged to take every client who walks through the door, but only someone that they can agree that the lawyer feels he can or she can represent conscientiously. Similarly, when I give a course, when I offer a course I have to take any student who is who presents himself, who's qualified to take the course. And I like to say where I teach, no matter how much ink or metal on their bodies, that's visible. But I teach all students. But when I do independent study with a student, I can make a decision. I don't have to give a reason as to whether or not that's a student I want to work with individually or not. And so it seems to me that even though there are going to be some difficulty drawing lines, right? It's easy to talk about a cake you buy at a counter, a little harder, a wedding cake that might have to be delivered. But still, it seems to me that you could draw a line there by legislation, sorting it out, and in a way diffuse the controversy in that way. My third proposal would be even more complex, and it would concern what to do about the law of marriage and its incidents after Obergefell. As Adam McLeod has pointed out in a recent law review article, there are all sorts of issues concerning presumptions of parentage and severance of biological ties, which still haven't been solved in the state of Massachusetts, where same-sex marriage has been the law for, 12 years now, or 13. And these things, sooner or later, will have to be worked out either by the court, but why not by legislation? And here, I want to propose a kind of radical solution that, however, a radical change in marriage law, that, however, I think would actually accommodate the different parties. That would be a law that had, say, these three parts. First, the state would define marriage simply as a civil union between two parties, for the union of property and government benefits and those purposes. Secondly, that marriage would be recognized by the state simply by signing a license and appointing a time in that document before a registrar that the marriage would go into effect. And thirdly, that the rights and duties of parentage would inhere in the biological mother of a child and the biological father, if known, where any other agreement would have to proceed through the instrumentality of the state, adoption, and so forth. It seems to me that, although the details of all of this would have to work out, there would be certain advantages to this. It would satisfy the courts with regard to equality. It would allow Christians to preserve their own rights independent of the states. That's the point of the registry, without having to make a minister actually be the formal state witness, as has been the case to a marriage. And finally, it would preserve for those in traditional marriages the connection between marriage and children without making that a formal requirement of the state. Because it seems to me that if you take the old law of marriage as it exists, presuming parentage in the couple, and now include same-sex marriages in that law, you have this real sort of factual problem that you're requiring the severance of a biological tie between the parent and the child, and that actually there's some support in the law for that to exist. So the general question, whatever you think of these particulars on the particular matters, isn't there a role for legislation in this way, trying to settle some of the controversies, making the deals in such a way as not to force the logic of religious liberty, so that we're faced with a kind of tragic choice between the tradition of non-discrimination according to which our marketplace operates and much of our society operates on the one hand, and the deep religious convictions which are protected by our Constitution and critical to the human good.
Would you like to make a brief response before we open the floor?
Sure, I'll do that quickly. First of all, I would want to stress one piece in particular of what Professor Georges said, which is the importance of thinking about religious liberty outside the terms of so-called social contract. And I think that's something, it might be the most interesting thing that Madison really brings to the question, the most unexpected thing, is that he specifically wants to say and repeats, especially in the Memorial and Remonstrance, which is before the First Amendment, that the right he's talking about precedes all of society. It is not a function of the social contract. It is a precondition for society. And it's an important distinction for us in thinking about just what religious liberty actually is. What I very much like about what Professor Stoner lays out for us is the inclination to find accommodations. That's, in a lot of ways, what's missing in a lot of these debates we have, where all sides seem intent on finding resolutions that they are ultimately satisfied with. But what we really ought to expect out of our democratic society in situations of fundamental differences is that we should be able to find accommodations, ways of living with difference rather than ways of resolving differences based on the force of the majority of the moment. And I do agree that the way to do that is through legislation much more than through adjudication. That ultimately, the way to do that is to work together to find an arrangement that in an enduring way can help people continue to disagree and live together as citizens. And so to build spaces for people to live their lives in somewhat different ways in one society that is united by some very fundamental assumptions about what its purpose is and what the human good is. It can be done. It surely can be done. It has been done in America. It too often isn't what we're trying to do now around these issues. I think changing that, especially by looking again to legislation and not simply leaving everything to the courts, it's not the fault of judges that it works this way. Everybody goes to court. That's the first instinct. The first instinct should be to find a way to so arrange the rules that we don't have to make everything a federal case. And I think everyone on all sides of these questions has fallen down on that job in the last few years.
Okay. We're going to open the floor for questions now. I will ask you, since this is being video recorded, to wait for the microphone and to make your questions brief. Dean Minow.
Well, first I want to say thank you to Professor Glendon and to our fantastic speakers, and it's really the kind of event that Yuval Vaughan, who endowed this series, would have relished. I think that the ideas, the reaching between the practical and the broadest kind of theory is exactly what he would have hoped, and I'm very, very grateful to all of you. I very much appreciate, Professor Levin, the emphasis on obligation as well as right, so often missing, frankly, in discussions of secular law. I also very much appreciate the introduction of the communal as opposed to the individual. And here, Professor George's invocation of John Rawls is so appropriate, because if we live in a world in which we have overlapping consensus, but people actually have different views about what's prior, individuals or groups, for example, rights or obligations, those fundamentals we may not agree upon. And it's actually in that spirit that I want to pursue Professor Stoner's suggestion about the compromises that are possible, accommodations that are possible with legislation, might be true also with contract, as you explored, and other kinds of private ordering. And it's to identify a possibility, but then a problem. So the public-private distinction is another tool that we inherit from the liberal tradition, from the Protestant tradition, that we deal with religious difference by permitting freedom in the private sphere, and either excluding religion or having some kind of all religions in a kind of superficial way in the public sphere. Now, that's provided some room for accommodation, but there are some real problems for people who want, for example, Sabbath observance. That doesn't really work. If it's just about your own Sabbath observance, what about everybody else? And we can go on and on. So the individual versus communal ends up being a divide that's recapitulated with the public and the private. But the one I want to pursue is really introduced by some of the accommodations that Professor Stoner recognizes. So where is the public-private line? Is the public-private line, where should it be? If the government is funding services that are provided by a pervasively religious organization, has the public entered the private? Can the private say, no, we still have our religious freedom? How about the tax exemption? Should we understand the tax exemption as, well, that's just recognizing a pre-existing private space, or is that a subsidy from the government? And of course, a further extreme is, how about simply the permission to practice your religion and not be punished for it? Is that private or is that public? Thanks.
Would someone like to respond to that series of questions?
Well, I'll start on the the line that I was drawing, the commercial line, is not exactly a public-private line. It's a line that I actually get from Justice Harlan's great dissent in the civil rights cases, where I, in a way, first learned about the common law duty to serve the public generally, and that the Accommodations Law, the early Civil Rights Act, the 1875 Act, was meant to develop that. And as far as right, I mean, and this becomes the problem in the case, right? Because the majority of the court decides, well, it's state action to make a law like this that's governing what people do. But Harlan says, well, no, because those who are acting in the marketplace are in this kind of space, which is, as was said in a case about the same time, affected with a public interest. It's the market is a kind of a public thing, but it's also a market where private individuals interact publicly. So it's a great mediator between the public and the private. So, by the time we get to Brown versus Board of Education, and we're in a world where increasingly government is organizing our lives, and there are big government institutions doing all sorts of things that in the past have been done privately, the public-private line becomes the critical line. Although even then, with the Civil Rights Act, commerce includes accommodation. Well, there's sort of something public if things are moving in interstate commerce and so forth. So you get the defense of that act, the kind of workaround, so that the state action doctrine remains in place. But in fact, the public accommodations is now supported by recognizing this kind of commercial sphere. So I guess that's to say, I'm not sure now, of course, if your question is, well, okay, but what do you do about the public and private? Sure. But boy, they operate in funny ways. I remember once when I was here, Peter Gomes preaching on Good Friday and explaining that he had to argue that he couldn't attend the divinity school meeting that was scheduled for 3 o'clock on Good Friday, because that's when you always have a Christian service to commemorate the crucifixion. But on the other hand, down at LSU in Louisiana, we always have Good Friday off. So, I mean, either we save a day to the schedule by incorporating our spring break during Holy Week, or else, we add it as a day. But there's no question in a state like this. So again, the public-private, I don't find it a useful distinction always for settling these matters, that there's this sort of realm of civic society where so much of this operates. And maybe the public-private distinction just isn't what's going to be helpful in this situation.
I would say one more thing. Well, first of all, thank you for the great question, which is just the right follow-up on this discussion, I think. And it seems to me that the private-public distinction is a search for a duality where there are many more distinctions than that in people's real experience. Actually, Rawls is quite good on this point, too. In a sense, there is a huge space between what we so often mean by private-public distinction, which is really a distinction between the individual and the entire community as a whole, the individual and the state even, or the individual and the nation. Between those two, there is almost everything that we actually do in life, from the family to the community to various kinds of institutions of all sorts, of commerce, of education. Some of those are religious, some of those are not. It would be very hard to say about most of them whether they're public or private exactly. They're done in public, but they're not governmental. And the space for those kinds of communities, for those kinds of institutions, for all of civil society to exist, the protection of that space is a crucial role of the government. And the question of what the law should do, it seems to me, should very often be directed by an understanding that its purpose really is to guard the space in which all of that happens, not to take it over, not to make it unnecessary, but to protect it, to shield it. Especially the national government should have a kind of protective function over civil society. And that does mean that distinctions between public and private just end up being less useful than they might otherwise be in a lot of these kinds of questions, because we're talking about things that people don't do individually, but that they also don't do as a political community, but rather do as smaller kinds of sub-political communities.
The Dean's question raises for me the question of the challenges for people on the competing sides of these culture war type issues that both of my fellow panelists raised. They're challenges for people on both sides. Okay, well, could we get a little bit into what those challenges are? And I'll do it this way with reference to legal education and the culture of the legal establishment, the great firms and practitioners and activist legal organizations, which you now have, of course, across the spectrum, from the ACLU to the Beckett Fund to the American Center for Law and Justice and so forth. If I understand the history correctly, and someone can correct me if I don't understand it properly, a kind of change in attitude about what legal education is about and what law is for begins to emerge with the great decisions of the Warren Court. Great, not in saying I approve of them, but saying that very important, socially very important, Brown versus Board of Education and so forth. And so people come flooding into law school because law is now understood as an instrument of social change. And by instrument of social change, that means instrument of change of conscience, consciousness, not just institutions. We're going to change society through the instrumentality of the law. I think that's really different. I think if you go back to prior eras, and of course prior eras, and Professor Stoner is an expert on this, you don't see anything quite like this new conception of law as an instrumentality of social change that really attracts idealistic young men and women into the profession. They're going to change the world, change institutions, but more fundamentally change consciousness through law. So, Yuval, the challenge, I think, at least on one side of this, is are we actually willing to live with the difference that you're asking us to live with, as opposed to advocating legal changes not just for their own sakes, or even for the sakes of changes of institutional practice, but to actually change people's minds, to change the consciousness. Just as racism was very significantly affected, what's going on in people's heads affected by the legal changes, not just those of the legislators, the Civil Rights Acts of the mid-'60s and so forth, but those of the courts. Shouldn't we be doing the same thing to change what, from this perspective, are the bad attitudes that gave us the institutions that we have and that we now want to change, so traditional marriage or whatever it is? So, and I think that's a question for legal education, because I think a lot of people in the legal education establishment came into it with that idea. They were among the young idealistic men and women who flooded into the legal profession and into law school and legal education because it was an instrumentality of social change, and they're going to teach their students on that set of assumptions.
We have a couple of hands up. Gentlemen back here.
Thank you. My name is Robert Batista, and I'm a 1L here. I wanted to focus on sort of the distinction that two of you made between religiously motivated action as what you want to do versus what you must do. So I definitely agree that makes sense as a matter of common sense, a matter of philosophy. But I find that maybe it's harder for the law to make that distinction. Mm-hmm. And not only is it harder, but is it really something we want the law to do? Because it sort of seems to go to the sincerity of someone's belief. We're going to have courts and judges try to interpret religious texts and see if they really must do these things. And then if we are going to be deferential, then it seems then we start blurring the line between religiously motivated action and philosophy, right? This is my philosophical objection. I believe I must do it based on some set of norms that I have. And so then those start coming in, and suddenly it's not religion anymore. So I'm just wondering if, those two tensions, how we can resolve them, if at all.
Yeah, it's an excellent question, an important question. I think it gets at a difference that you frequently see between what you might think of as legal philosophy and political philosophy, because it raises the question of whether the hard cases should define the general rule, right? If you think about, especially about religious liberty in terms of the general rule, it's actually not that difficult to see how it ought to work. For the most part, it is quite workable, has been quite workable in practice, but it does confront us with some especially exceedingly difficult circumstances where the question is a very difficult question. It's the sort of thing you put to judges, and it is put before judges. But the question is whether the kinds of decisions that those judges have to make in those hard cases should then define the general rule and work on society as though it were not possible in general to accommodate differences, and therefore instantiate in society a kind of taking to its logical conclusion of what is actually a very exceptional situation. It seems to me, and in a way, it's a kind of one-sentence expression of a Burkean approach to political philosophy, that you shouldn't take anything to its logical conclusion in politics. That's how you allow for freedom to persist and differences to exist. And a lot of the problems we have now involve taking to their logical conclusions premises that we've had to confront because of very exceptional cases. And rather than living with hard cases, we've allowed those hard cases to define the general rule. It's obvious why that would happen. We want our laws to be logically coherent. We want things to make sense, not just to work in practice. And for the most part, that is doable. But I also think we have to be better at living with the fact that it is not always doable, and that a rule with exceptions is actually the right way to think about freedom.
If we can take one more. Yes, go ahead.
To the panel, I'm Rory Schachter. I'm in the government department at Harvard. To the panel, or whoever wishes to field this, do you think that the concept of conscience, as it was used originally in arguments in favor of religious toleration, is still workable today? The reason I ask is that it seems that the majority of people to whom, say, Locke's argument for toleration was first pitched were believers, and also believing Christians. One sees his inclusion of others beyond Christianity or monotheism is spotty at best. In the United States today, I noticed Barack Obama in a second inaugural address mentioned, in addition to a few other faiths, non-believers. I don't know how much of the percentage of the population are non-believers. At Harvard, the largest chaplaincy is the humanist chaplaincy. I don't know exactly what they believe, but that's the largest one. So is that a problem that atheists or non-believers are kind of left scratching their heads as to what the protection of conscience would be, and that even if they respect what they hear is the conscience of believers, that they see conscience as a choice, an identity, whereas the believer would see conscience as a call, something coming from the outside them that they are obeying. And so one would think there would be a fundamental problem of communication here.
That's a wonderful question. My own view is the one I articulated. Religious freedom is grounded in the need to protect a certain good, and I described that good to you as the raising of the great questions, the honest effort to answer those questions, and then the effort to live out a life with authenticity and integrity in view of one's best answers. Now that good is realized in the lives and in communities of people who reach all sorts of different conclusions about the answers to those questions. And so leading lives of authenticity and integrity will mean leading different kinds of lives. There will be Mother Teresa, and there will be Albert Camus. Camus might have been a member of the humanist chaplaincy if he were here. But nevertheless, even on Mother Teresa's account, Camus would be a person who grappled with the great questions, honestly sought the answers and then was determined to live a life of authenticity and integrity and not a phony life in view of his best answers. You wouldn't want to compel an atheist to make the outward expression of religious faith, or even encourage him to yield to the temptation to do so, let's say, to get ahead in a culture that honored and valorized religious observance a lot more than ours does. You would want people not to be fakes, not to go to church just because going to church would make them look good. That would be inauthentic. That would be damaging to a genuine good in their lives. Or to not go to church in a culture that might be a little more like ours, where maybe if you were understood to be a conservative religious believer, it might harm your career. It might make you suspect. Nevertheless, we'd want to encourage people to live with authenticity and integrity, and certainly not do anything in the law that would impede or discourage them. So on my conception, the right to religious freedom is not just for believers. It's for unbelievers as well. It's for the spectrum of people, and not just because I've got some abstract idea that it's nice to let people be free in religious matters. I don't believe in abstract right. I think there's a genuine good realized in the life of Camus and realized in the life of Mother Teresa, although they come to diametrically opposed positions about theism, Christianity, and so forth.
Madison wanted to use the term rights of conscience in the First Amendment, but it wasn't chosen, and I think because there were certain objections about it, maybe not least, that in a way conscience, it might even be a logical problem for law to recognize conscience, since conscience is always the individual decision how in a particular circumstances to apply the law, whereas the law is necessarily general in this way. I don't think that the change has been quite as dramatic as you suggest, or as people usually suggest when they talk about a secularization of society. Washington, in his farewell address, makes a nod to minds of a peculiar peculiar character or a particular.
Drafted it. He was talking about Jefferson.
Yeah, I think so, but also a sense of the elevated or deist, right? And who can comport himself fine with the law, but for most people, religion serves that purpose. But there was a recognition that there was that the Jeffersonians of Harvard might go a different way.
This has been all too short, but we do have to conclude. I want to thank the panelists, and a special thanks to Dr. Levin and all of you for coming, and Dean Minow for your co-sponsorship of this wonderful Vaughan series.